on 8 things that you should know about Florida's personal injury laws. Number 1, Florida is a no-fault state. This means that it is required that every driver carries a minimum of 10,000 PIP coverage, personal injury protection coverage. This means no matter who is at fault, your own insurance carrier will pay the first $10,000 of your medical bill. Number 2 of 8 things you should know about personal injury law in Florida. Just because Florida is a no-fault state doesn't mean that the at-fault party is not responsible for your injuries. If the at-fault party causes any type of permanent injury, such as permanent disfigurement, permanent scarring, permanent loss of bodily function, and even death, then yes, the other party is still responsible for those injuries to you. Number 3 of 8 things that you must know about Florida personal injury law. Your statute of limitation is only 2 years. This means you only have 2 years after an injury, after the accident, to bring a claim against the at-fault party. Only 2 years. There are a few exceptions, but we won't talk about them tonight, okay? Number 4 of 8 things that you must know about personal injury law in Florida is that your pain and suffering compensation is valued by numerous factors. Number 1, the severity and type of injury that you have. Number 2, your required medical treatment. Of course, some injuries just require much more severe treatment in order for you to get better. For example, you may need surgery or some type of medical device, and that will be calculated into your pain and suffering. Number 3, your recovery period. So if it's taking you longer to recover from your injuries because you need more rehabilitation, that will be taken into account for your pain and suffering. And number 4, the effect of the injury on your life. This is most important, right? Because this is an injury that completely changed your life. You're completely different after the accident than you were before. So that is taken into consideration how your life has changed. Number 5 out of 8 things that you must know about personal injury law here in Florida. Evidence is key to your pain and suffering claim. What kind of evidence do you need? Number 1, your doctor. Because your doctor is a professional, he or she may be called as an expert to testify on your behalf. Number 2, a mental health professionals. Depending on the severity of your injuries, sometimes those type of injuries really impact your mental state. Number 3, your family members, families, friends, anyone that knew you before the accident and after the accident that can testify in what way the accident affected your life or has changed your life. And number 4, yourself. Your experience can also be used as evidence. Best practice is to keep a journal after an accident. You could go ahead and journal your pain, your suffering, your injuries, your experiences, everything that's different because of the accident. Go ahead and journal those so that you could always have it to go back to when you need it if you go to trial. Number 6 out of 8 things that you must know about personal injury law in Florida is that Florida is no longer a pure comparative state. We are now a modified comparative state. And this means that if you are more than 50% at fault for an accident, you get 0 recovery. You cannot recover anything, any amount for your injuries if you are, again, more than 50% at fault for the accident. It's not good at all, but hey, that's the law here in Florida. Number 7 of 8 things that you must know about personal injury law in Florida. You can sue your government for their negligence. So if you get hurt because of a government official, police officer, correction officer, any person that works for the government, you get hurt because of that person's negligence, then yes, you can still sue the government. Now there are a couple rules that we have to abide by. For example, you have to give them about 6 months to investigate your claim before you could actually file a lawsuit. Also, There is a limit of $200,000 per claim that you can sue for, and other rules that you should probably get an attorney to outline for you. And number 8, out of 8 things that you must know about personal injury law in Florida, you can sue for punitive damages. That's right, really quickly. Punitive damages are damages meant to punish the wrongdoer because they willfully did something so reckless that caused your injury. So it's not mere negligence. A good example would be someone who intentionally drank and then get behind the wheel and causes an accident. In a situation like that, you would be allowed to bring in an extra count for punitive damages. Punitive damages are rare in Florida, but we do have them, and there is a cap on punitive damages when it comes to personal injury. The cap is either 3 times the amount of compensatory damages, meaning damages that you receive that are not punitive, or $500,000, whichever number is greater. This is a good thing for us. The cap isn't so good. However, punishing an individual who recklessly, willfully get behind a wheel while drunk is a good thing. That's all I have for this series of videos. If you have any questions, just let me know. Rolanda Adolph with Adolph Law Group, personal injury attorney in Florida. You have questions, as always, I have answers, so ask. Good night.